Well, good evening everybody, and thank you for coming out on this cold winter's night to talk about family provisions orders under Part 3 of the Succession Act, which everybody knows probably came into being in March 2009, 1st of March. The focus of this talk is really going to be about blended families, because you won't be surprised to know that a lot of cases the court deals with now are made up of blended family problems, primarily where the parent dies, leaving the majority or substantial part of their estate to a step-parent, and then you have the stepchildren wondering, what will I do? Will I make a claim now? My father's just died, but he's been married to this woman for 30 years and I really don't want to make waves, and I sure don't want her to feel mistrustful or to be thrown out of the house. So invariably, in my experience, the stepchildren do not make a claim on the estate, and they wait until I've got a case at the moment, the stepmother dies, and unfortunately seems to be the motto, not my kid, not my problem, and the step-parents leave it to their own children. And they do not leave anything to the stepchildren, or a very small amount. And this is a very common problem. And what I really want to focus on tonight, I'll go through all the eligible categories, but these are a little bit tricky, these claims. And specifically, if you get people into your office whose natural parent has died, but they've got this step-parent situation, I'm going to equip you to answer these people. Because you may have two brothers, and if they miss that opportunity to make a claim when their natural parent dies, one may have a claim, the other won't. And that's the case I've got right now. One brother is out of the game completely, and the other brother is in the game. And I'll tell you why. I'll jump you through those steps. Okay, so eligibility. In New South Wales, we have 6 categories of eligibility, and that's found in Section 57A to F of the Act. Now, there's the easy categories are these: husbands, wives, de factos, and children. And these are the easiest people to represent, and they only need to get over what we call the general jurisdictional hurdle, and I'll talk about that later. And then you have the ex-husbands and ex-wives, and that doesn't include ex-de factos, just the ex-husband and ex-wives. And then you have what I call a miscellaneous category, and these are people who must have had a whole or a partial dependence on the deceased at any particular time, or they are a grandchild, or they must be a member of the household of which that deceased was a member. So they have an extra 2 hurdles to get over. And then the final category is people who were close to the deceased. But the most difficult category to step over is for these stepchildren. Now, that miscellaneous category opens the doors to a lot of people, and a lot of people who weren't related to the deceased in any way. So that can be ex-de factos slip in there, nieces, nephews, housekeepers, you name it. You don't have to be related to the deceased. But for the stepchildren, they have to squeeze within this Section 57A miscellaneous category, and a lot of them cannot do it. So a lot of stepchildren miss out. So the extra hurdles that the stepchildren have to go to is, firstly, they have to get over the dependence issue. They have to show the court that they were dependent on the deceased. There's been some fairly sobering judgments in this regard. One in particular, Ellis and Sidler from McCready in 2011. But this is a very difficult area because it's a question of fact, it's a complex question of fact, and the age of the child matters. Now, when I'm talking about a child here, I'm not talking about inferring that they're minors, I'm talking about the quality of the relationship. But This is also relevant to grandchildren. They also have to prove dependency, but they don't have to prove the second limb. But it's very difficult. It's been described as financial, economic or material dependency, so a mere emotional dependency will not cut it. It's got to have a financial component to it. For instance, the stepchild could have been unemployed and living with the deceased and the stepmother and being provided with free food and free accommodation. That would get you there. It cannot be a one-off act of generosity on behalf of the grandchild or the deceased step-parent. It needs to be a settled, permanent basis or arrangement. It doesn't have to be at the same time that there are members of a house. And I'll give you an example of Carrara and Crook. This was Associate Justice McCready. And he found that a child that had lived with the deceased for a 2-year period from the age of 16 through to the end of their 17th year was provided with food and accommodation and so on, did not constitute a dependency. So the age of your client is unfortunately a very critical factor. So what the court said was that that was not a direct dependency. That kid just lucked out because the mother was there. So it was consequential on the mother being in this relationship. But then McCready found that that child, then at the end of the 17th year, moved out of home, got into a de facto relationship, had some children. Several years later, that relationship broke up, and she moved back to that house with the mother and the deceased, the stepfather, for only a period of 4 months. But because now this child was over 18, it was considered that this was a true dependent relationship, even though it was only for a period of 4 months. So the age makes a difference. I think children are more difficult than adults. So you get over that eligibility issue, the dependency, and then you've got to go to the second limb, which is they have to have been a member of the household. And this is where so many stepchildren just miss out, because often they've moved out of home before the father had the new marriage and so on, and they've never, the case I'm running at the moment, that other brother never lived with them. And so even though his father's inheritance has been passed off to the other side of the family, they just miss out altogether. So the second limb is being a member of the household of which the deceased person was a member. Now, the Act doesn't define this, and nor does the Act state that there's any requisite period of time. It's all a question of fact, depending on the judge. I can tell you that the courts have held that spending school holidays over a 5-year period, 2 weeks in August and 6 weeks in summer, did not constitute being a member of a household. There needs to be continuity and permanency, and lodgers and boarders rarely come within it. And there seems to be a tendency in the courts to assume that you can only be a member of one household at a time, but I think that is very overripe for being revisited. I know children that are certainly members of 2 households, and they have identical clothes at one house, identical clothes at the other, and they share the time really equally between 2 different families, and they're certainly members of 2 households. So I think in some ways this legislation is still out of step with the real world, and it's still largely modelled on the UK Act. So once the parties get over that two hurdle, the dependency and the member of the household, then they also have to have another threshold test, which is called the special jurisdictional hurdle, or factors warranting. Now again, factors warranting is not defined anywhere in the Act. It was set up initially as a filter, so you could get rid of a lot of claimants at this factors warranting stage rather than go on through the process, but it just hasn't worked like that. And the reality is that the factors warranting process is only ever decided once all the evidence is in, because the reality is the factors warranting considers the same type of issues as the general jurisdictional question, and the same evidence is applicable for both. The only groups which have to do the extra special jurisdictional issue, as they call it, is the ex-husband, ex-wife, the miscellaneous category, and the persons living closely, the F category. So the husbands, wives, children, de factos don't have to go through these extra levels. But in terms of stepchildren, a really critical factor warranting is where is the origin of the property that comprises the estate? That is, did it derive from the stepchild's parent? And this is a really critical factor warranting. And there's a case called Mackenzie and Top, which has been followed time after time by single judges in New South Wales. And what that says is that, I'll just read you a short passage from there because it's pivotal. He says, other things being equal, right-thinking members of society are likely to accept that the needs of the widow are paramount, and the needs of a widow in a second marriage should rank in priority ahead of claims of the children of a first marriage. And I think that's right. I think that probably does capture community expectations. It's always a question of fact. It's not an immutable rule. But equally, upon the death of the widow, and as it were in the event of a surplus, most would surely say that the children of the first marriage should rank for their fair share. And that's right, I think, as well. For once the widow is gone and therefore no longer in need of provision, her needs no longer warrant that the children rank behind her or the chosen successors. So that's a very strong point, and you need to explore that with your client and make sure it goes in the affidavit. So you need to track back where the house came from and so on. But still, there will be deserving stepchildren who just totally miss out. Oh, that's very kind, thank you. So then we get to the general jurisdictional question, which is what each of the 6 categories has to step through. And it's funny, but until recently it was unanimously thought that this 2-stage question, or whether there's been adequate provision for the proper maintenance, education or advancement of the applicant, everybody thought that the new Act just carried through that 2-stage inquiry test set out in the High Court case of Singer and Bergman. And in fact, there was a case, Keep and Burke, in 2012 in the New South Wales Court of Appeal that said yes, the same test applies, the 2-stage inquiry is still relevant, it's still the test. But then after that, we've had another New South Wales Court of Appeal case called Andrews and Andrews. And there we had 2 eminent judges, President Alsop, as he was then known, and also Justice Baston, wasn't it? Baston? And they have said no. They've said, in fact, the discretion is now wider and you don't have to do the two-stage inquiry any longer. In fact, I think that's right, and I agree with that, and I think the 2-stage inquiry is a bit artificial myself. But then we had Justice Barrett in that case as well, and he said, hey, wait, the 2-stage inquiry certainly does apply. We've just dealt with that in Burke and Keep, and he said, certainly, at least in terms where a child is involved and there's been no previous family provision order, the 2-stage Singer and Bergman test still applies. So where do we go from here? Well, we need High Court resolution of this issue, but I can tell you that at the moment all the trial judges, including Hallen, who does a lot of these matters, are following Barrett. But there's still a rider in there because, and Hallen's doing this as well, they're limiting the 2-stage inquiry to a child. A stepchild is not a child. It does not come within the definition of child. So the argument's certainly open in the right case to argue that there is a new test. And you understand that Singer and Bergman no longer applies because we've got new legislation. So it's authority for the last lot of legislation, but it's not authority for this legislation. So we have another open question in these cases. And I think in the right case, particularly with a stepchild or somebody like that, the argument should probably be raised that there's no longer a two-step. There's no authority that the two-step inquiry still applies to a stepchild. So it's open. So we'll see some High Court activity on this, I hope fairly soon really, so that at least it's sorted one way or the other. But having said that, because the courts are still applying it, I'll just briefly run through it. I've left that page. Anyway, the first question they have to ask is whether the applicant has been left with an adequate and proper amount in all the circumstances of the case. And if they answer in the affirmative, they still don't have to go on to make an order in the second stage. They can still knock back the applicant at that point. The power to make the orders under the Act is extremely broad and unfettered, and they can make it out of the estate or they can make it out of the notional estate. And they can fashion all kinds of orders. It's quite amazing. They can be very flexible, and the courts are very flexible. So what is a notional estate? Well, essentially, a notional estate is like a clawback provision, and not all the states have it. I think some of the other states are thinking about it. But so if your executor distributes the will, and in other states that would no longer be considered part of the estate, we can claw that back so that the court can make orders. And also property transactions that were, under the old Act it was called a prescribed transaction, and now they call it a relevant property transaction, set out in section 74. So you've got two basic circumstances where it can be notional, where it's been distributed by the executor and you want to claw it back, or where it's part of a relevant property transaction. And in those circumstances you can claw it back, but where it's a relevant property transaction, there must have been an intent to deprive the estate. So you've got to look to intent. It's a little more difficult. Where it's under the executor distributing, you don't need any intent at all, and it must be within 3 years of the date of the deceased. The other thing is that, what was I going to say? That's right. There's a lot of restrictions on the notional estate. This is not a broad, unfettered power of the courts. They can make a notional order on their own motion. They don't have to have the applicants or anybody else raise it. They can do it themselves. But they can only do it if they first find that there are inadequate funds out of the estate to meet the orders, and or the costs of the parties. So that's good for lawyers. Costs can be, you can claw back notional property to pay for the legal costs. And there are a lot of other restrictions. It's not a broad, unfettered power. This is very restrictive. But having said that, these orders are made every day, and they're definitely part of the New South Wales landscape. So that's all I was going to say on the actual legal aspects of family provisions. And then I was going on to discuss the new practice note. Well, the new practice note does change things. The list is no longer under Senior Deputy Register Musgrave on a Tuesday afternoon. It's now with Justice Hallen on a Friday morning at 9:30. Justice Hallen gives allots 4 minutes for each person to go up. So he's timed it. He's got over 100 matters in the list every occasion, probably about 130 plus in the list. It's a busy list. So don't waste time. He expects it bang, bang, bang. Once you file the summons, there'll be about a 4 to 5 week period before the first directions hearing. Now, this is one of the big changes. Under the old scheme, you did not have to file an affidavit. Now you do. You have to file an affidavit for the claimant. You have to file an affidavit of costs and disbursements, calculated on an ordinary basis, up to the mediation. And you also obviously have to file a notification for any other members who might be potential beneficiaries. Now, the other thing that you should note at this point is that it's now only a 12-month statute limitation period. Under the old Act, it was 18 months. So if you get a client coming in at the 11th hour, forget the practice note, just file the summons. Forget the affidavits, forget all that. Just get that summons filed, preserve the claim. Because the courts don't overturn lightly this statute of limitations, and the parties cannot agree or consent out of it. It's only if the applicant can show sufficient cause, and the courts don't give it lightly. So save the claim, don't worry about the affidavit. You can do that later. You now know you've got about 5 weeks. Just make sure it's ready a week before that first directions hearing, and Justice Helen will be fine with that. At that first directions hearing, you will get a mediation date. Now, if you have a very small claim, it can cost $10,000 just to run a mediation. Yeah, it can. And that's an accepted, I'm using Justice Hallen's figure there, so he accepts that as a reasonable amount to run the actual mediation. The average kind of cost to get it to a mediation are 20 to 25, which seems to be reasonable. But if you have a very small claim, and I'm talking anything under 300,000, I think that you should try and even avoid the cost of a mediation and do an informal settlement. But make sure you get orders from the judge for it, so you're kind of a little bit protected. But rather than doing a court-appointed mediation, have counsel sitting in chambers and doing a negotiation over the phone, okay? You can settle them that way and you'll save a lot of money. And when you're talking small estates, the costs can just run away big time. The other thing to...
Jennifer, I understand they've actually stopped appointing mediation dates because they're all taken up till the end of the year.
Yes.
I think the settlement conference is the way to go for any side at the moment.
Well, they'll still be taking them, they're just into next year. And you can't get a hearing date this year either. Yeah. Right. Some of them you need a mediation though. Some of them you really do need the mediation. Yeah. Well, I think they're great for the small claims, but there are other claims which can get mucky. And I've got to say, some of these mediations in these family provisions can get very wild, okay? For me, they're a lot wilder and more hargy-bargy, if you like, than the commercial mediations that I do. And there's a lot of emotion there, there's a lot of hurt. And the only time I've heard of violence has been in a family court mediation. And it was a private mediation before Justice, can't think of his name, he's in my chambers, Morling. So that's the other thing. In these kind of mediations, make sure you have plenty of breakout rooms because you don't necessarily want the parties meeting each other. The other thing to remember about the mediations in an average size claim, like a $700,000 claim, you only get from 9:30 till 1, is it? 1. You get the half day. Now, I've never seen this done, but if you think you've got a tricky case, you know you've got tricky parties, and you're not going to get it done, ask Justice Hallen for a double mediation. I mean, you're obviously going to have to provide him with very good reasons, but I don't think enough people consider that, because once I can tell the mediation registrars will not set it down again. But if you get it from Justice Hallen at the beginning, bang, 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 these are the reasons why, that's just worth considering. And in the very big multi-million-dollar ones, you can consider a private mediation, I think. And a half a day sometimes is just not long enough. I've always managed to settle all the cases at mediation. Sometimes the half-day mediation has not been long enough, but we've managed to settle it some weeks down the track. And even in very difficult cases, we've managed to do that. The one thing I'd say about mediations is, not wanting to tell people how to suck eggs, but try and have a conference several weeks before and then another one again on the morning, because in those half-day mediations, you sometimes go and the other side doesn't even make an offer or a counter-offer for 1.5 hours. It just can't work in that environment. And what I pick up from that is that this mediation is their first conference with the client. First time counsel's met it's the first conference. So you can't do that. You've got to really prep them up. If you want to settle them, this is what you've got to do. You've got to meet with them a couple of weeks before and counsel, start telling them what to expect, how it's going to run, and then again, if it's a 9:31, meet them at 8:30 in Chambers for another conference. And then you will be ready to, they're primed, they're ready to go. And that's how to settle, and they really do settle. It's in everyone's interest to get them settled, I think. So if it doesn't settle at mediation, then you'll come back for another directions hearing, and at that directions hearing you'll be given a hearing date. Now, if you think the matter's going to settle, delay going back to before the listing judge, okay? Because once you get a hearing date, if you settle, you are still liable for payment, okay? So if you think there's any possibility of settling the matter, tell Justice Hallen and tell him that you want to adjourn it 2-3 weeks. He won't go more than 3 weeks, I don't think. But you will be liable for the hearing fee, even if you settle it. So that's something to remember as well. If you don't settle, you can put on. If you don't settle the matter, immediately review your affidavit, because you'll be given a limited time to put on further evidence if you want to. So you won't be given a lot. You might be given 2 weeks. You will be given an opportunity to put on further evidence, but will be given 2 weeks. So the message is, if you don't settle, start working on that affidavit. And I actually start working on it while I'm in conference, while I'm in the mediation, start taking notes and getting more out of them, because there's always a bit of wasted time in mediations. If you don't use it, if you settle, you haven't lost anything. But if you do need to get a further affidavit evidence, you've already started the process. And it gets them thinking too. There's also a form at the back of the affidavit, back of the practice note, which that's all. You really need to give that to your clients, get them to fill it in. You can literally fill it in and then come back to you and settle it. A tip with the affidavits, don't get drawn into he said, she said, he never did that, she never helped. Just keep it very simple and straight to the point. Some of the affidavits go on for 60 pages detailing every hurt and insult and fight and injury that they've had, and the judges hate it. They hate it. So keep it simple, keep it to the format that the judges really drafted between the Law Society and the Bar. And it should all work out very well.
So, Jennifer, what should you focus on in your affidavit? What's the evidence that's really critical to get your client over the line if they're making a claim?
Well, if it's a stepchild, you've got to say they were dependent. So you've got to, in the case I've got at the moment, it's like, well, he finished school, his father built on a room, sold his house, moved in, married the wife. I lived there. I was unemployed for 2 years. She fed me. She let me live there.
Financial, economic.
So you've got the dependency. You've got the member of the household. That's why it's critical to know this, because you won't get the affidavit properly ready. If they're younger children, be careful. And I'd say get it reviewed before you file it, if you've got time. It's better to get it right in the one affidavit.
Carry on with, he didn't go to the funeral, he never
Forget that. Forget that. Forget that. Forget that. It's appalling. It's an appalling way to present an affidavit. The courts don't like it, and it's not relevant. And that's our job to stop the emotion. And I think the draft attached to the practice note does a very good job of just keeping it brisk. The other thing, so you've got to look at the factors warranting. Like I said, the critical factor warranting in a stepchild is that the estate comprises the property of the father. So my father's property is this estate. My grandmother left her house to my father. This is her.
Of the new wife. Is that right?
Well, the new wife's dead now, remember? The stepmother's dead, but a little mean and left it all to her children.
Yes.
So that's
To the exclusion of her contribution. It's about.
well, it doesn't so much matter about the contribution, and you're not necessarily trying to shut out her kids, but certainly these stepchild should have a piece of the pie. After all, why should they lose their grandmother's inheritance, their father's inheritance? Because they were gentlemen. Well, one brother has, but one brother hasn't. So then you've also got to step through, but you'll see this very clearly on the draft affidavit, you've got to step through what your needs are, what your income is, how much the person you're living with is making, what your liability... Oh, it's critical. Absolutely critical. Oh, it's it. That's the general jurisdictional.
Absolutely loaded. Don't bother.
No. Talk to me first, Annette. I think it depends. Your station in life can be relevant. You don't have to be a pauper to have success, but it really depends on the size of the estate. If it's a small estate, forget it. But if it's a big estate, no. Think carefully. You're not necessarily excluded, not at all. Yeah, because it's all relative. Yeah. The only other thing is if you're a defendant acting against an applicant, if you don't put on evidence as to your financial status and means, the court will just assume that you are not challenging on that level, okay? You don't have to put on evidence of your financial means, but if you've got beneficiaries who are struggling, well then they should put it on, or the court will assume there's no fight. That's all I was going to say, unless there's some questions, please.
Just on the issue of these blended family arrangements,
Yeah.
How are the mutual wills contracts standing up?
Not very well. That was a question about mutual wills and how they're standing up. And the question was asked, are they standing up? I said, not very well. People don't do them, really. There can be tax consequences, and it can hem the other party in who may want to marry or does marry. It depends on the age of the people as well. It depends on a whole range of factors, but they're really not so common, and they certainly don't stop a family provisions claim. They do not stop a family provisions claim. What they can be useful for is as evidence of the testator's intent, and they would be allowed in as evidence on that basis. Yep. So mutual wills do not stop a Family Provisions Act claim.
I suppose just as an aside, this is a bit of a stupid question, I suppose, but on the issue about settlement mediation and so forth, with all of this new arrangements now, no win, no pay. How are you finding that as a general issue about whether people are discouraging their clients to settle in case they should settle at mediation and get on with it because it costs?
No, I don't. I don't see that as an issue because you get your costs at the mediation.
Yes, I know, but if you could just keep on going, I mean, if you,
Oh, no, but I mean, this is such an area of discretion. You don't want to go up before a judge.
well, that's what I'm asking. I mean, I know the judges are supposed to be putting a cap on the costs, but how well are they enforcing that rule to discourage people perhaps from continuing to litigate where they should be settled?
Well, they're very harsh on the use of senior counsel in small cases. So they have very harsh words for people who use senior counsel in a small case. Just don't do it. And I've got case law on that if anybody wants it. They will and they can cap costs under $500,000 Family Provisions Act claims. Oh, yes, they will. Yes. But most of the time people are sensible and people try and settle. Sometimes there's inexperience that stops this, but
I think that because
Yeah.
I'm indirectly involved in a matter where I think it's exactly the case. They're just stringing it along, keep stringing it along.
oh, the other side.
Yeah, because it goes into the national estate issue that you spoke about, where the parties didn't actually divorce, but then had separated and maintained a relationship, but left two properties as joint tenants.
Oh,
Now, you mentioned something about a 3-year rule.
yeah.
So could you just expand on that? Because this was some time ago. I mean, funny enough, I'm for the estate that the national property issue is a separate issue.
I'm just trying to give you the section. Okay, so where the property no longer forms part of the deceased estate because they entered into a relevant property transaction, and for this you've got to have intent, it's Section 82 provides a summary. So if that transaction took effect within 3 years prior to the death and was entered into with the intention of denying or limiting the estate, you can claw it back.
Well, in this case, what happened was that the deceased and his former wife owned two properties as joint tenants and never had a family law property settlement and just left the properties in that situation. So the notional estate is really the only asset of the estate. So it's the deceased interest in these two properties, which the ex-wife has.
Are you saying it's like a joint tenancy? Oh, you can claw that back.
So exactly. That's
Oh, yeah,
there's
you
no
can-
timing on that.
You can claw that back.
Yeah, there's nothing
Absolutely.
that happened about
Absolutely. Yeah, claw it back. In New South Wales, claw that back. You bet. The other thing is, I just wanted to say, I don't see enough people doing Calder banks or offers of comp.
Which is the best part of the process, do you think, to make a callback?
Certainly after the mediation, straight after the mediation, if not before. And you know the ones that I very much like using are open offers. Do an open offer to the court. They're beautiful. Then you get the judge on side and it's open and it's up and the judges love it. The judges love it. Use an open offer. It's a very effective tool. It puts a lot of pressure on them. But this is an area where I don't know why it is, but you just don't see people putting costs or call-to-bang offers in, no. So everybody should be doing that. It's important.
I've been taking the view trying to settle before the year is up. So having a process where I try and engage with the other side about the case and put one or two callback offers on, and then we've got to a point where we have to put it on because the 12 months is up. I'm starting to think that all that's done is sort of acted against my client.
What do you mean the 12 months is up?
The 12 months, but from the date of death to the 12-month time period.
Oh, I see. Oh, yeah.
So, do you think it's better just to make the application and then get into
Yeah, it depends. I've recently been involved with one where I'm doing just what you're doing, but it's a very small estate, and I've given them an affidavit, a summons, I've given them the whole bit, and I am trying to genuinely save costs, and they're worried and they know and they know that if they don't come to the party, it'll be filed. But if I can save all that money, I will. It's a
So it is still worthwhile.
maybe, maybe not.
In my case, it hasn't worked. We've had to but,
I think they have to know. You really have to have counsel involved so they know you are dead serious. Otherwise, well, do
council involved.
you know, in that case, I would write the letter saying this is a very small estate and give me your details and I'll give you a little section which says the executor's duty is not absolute in a small estate. You've got all that?
No, but I mean, I know that it's not. It's just that they all seem to think it is.
No, but I'll give you the case law on it. And otherwise, it's what is it? It's $1,000 to file a summons. File the summons. If it's a small estate, go straight to a negotiated settlement in council's chambers. But I think a very powerful tool is the open offer to the court. Yeah.
I might ask Jennifer and Graham to sit down and have something to eat, and then we can have some more questions.
Oh, how lovely!
Thank you.
That's great.